My name is Thomas Berry, and I'm the director of the Robert A. Levy Center for Constitutional Studies here at the Cato Institute.
Can you tell us in a very, very simple way, what is the Supreme Court and what is its role?
The Supreme Court is at the very top of the judicial branch in the United States, which of course is one of the three branches of government. And the purpose of the judicial branch, and especially the Supreme Court, is to resolve specific disputes. And those disputes might be about the meaning of the Constitution, they might be about the meaning of federal statutes, but essentially anytime there's a dispute that turns on a question of federal law, it can be litigated in the federal court system and ultimately potentially up to the Supreme Court. Of course, as the very top court, they decide issues of law for the whole country, and they only take a small number of cases on the most important issues and the issues that have been the hardest for the lower courts to figure out.
When you say specific cases, are there rigid rules around it? Does it depend on the judges? How do they choose these cases?
So the Constitution itself defines what can get into federal court. It says the judicial branch answers cases and controversies. And over the years, the Supreme Court and other courts have worked out essentially a doctrine called standing that says you can't get into court unless you have a specific dispute that something hinges on. The government took your money, the government took your property, you were injured in some way, and if you win the case, your injury will be fixed by the court system. Those are the only types of cases. If someone just says, I don't like this law, I think it's unfair, but they're not injured themselves, they can't bring a case.
What kind of answers does one get from the Supreme Court? Do they talk about the facts? Do they choose like a specific answer from the questions from the case? What are the kind of answers we get from the Supreme Court?
One thing that differentiates the Supreme Court is that they grant review of specific questions, not necessarily of the whole case. And that's different from the lower levels. The Supreme Court does not have to take every case. In fact, they take only about 1% or less of the cases people ask them to take. And sometimes a petition will ask them to answer 3 questions, and the Supreme Court will say, we're only granting review to ask this 1 question. Often that means there's a lot more to be litigated in that very case after the Supreme Court has its say, but they're really just focused on answering that 1 question to give greater clarity going forward.
When you say they only cover federal law, but also it can start at a state and the state law can be deemed unconstitutional. So can you tell us like the relationship of going from state law to federal law and how they come together?
The United States has a complicated system of federalism that's unusual for countries, especially of the size of the United States, where you have a federal system, federal statutes, a federal constitution, and 50 different states that all have their own constitution, that have their own statutes. The federal system is only when the case hinges on some question of federal law. But as you said, sometimes a state and a federal question can be intertwined. Does a state law violate the federal constitution? That counts as a federal question. More often they'll file in federal court, but sometimes they'll go through state court all the way up to a state Supreme Court. And sometimes the Supreme Court, the federal Supreme Court, grants review of decisions by state Supreme Courts. But when they do, they can only review the questions of federal law. So a state Supreme Court has the final unreviewable say for questions of interpreting state statutes.
You said that America works a little bit different than other countries, and specifically you have a common law system which kind of gives the judicial power a lot more weight on the separation of powers. Can you tell us a little bit about how important the role of the Supreme Court is in a system like this one?
Yeah, most continental countries, France probably most famously, have what are called civil law systems, where courts aren't supposed to be making the law themselves. They're not supposed to be creating doctrines. They're simply supposed to be interpreting statutes. And at least in theory, all legal issues are supposed to come from those statutes, not from the so-called common law. Now, one actual controversy in U.S. history is everyone knows there's state common law, but is there also federal common law? The Supreme Court actually reversed on this question. Originally, they said there is, but then in a famous case called Erie Railroad versus Tompkins, they said, no, there's no federal common law. There's only state level common law. So if you go to law school, you're going to study a lot of basic things like contract law, tort law, all those common law things. Those have all been developed by states, not so much by the federal government. But importantly, we do still have a system based on precedent. And that's really crucial crucial. The Supreme Court precedents are binding on everyone below them in the judicial branch, as well as binding on the Supreme Court in the future, unless they take the unusual and drastic step of overruling one of their prior precedents, which is quite rare and which they do reluctantly because they want things to be predictable. So that system of precedent is very much tied to the common law ethos we have in this country. We're discovering the best overall answers by relying on the decisions that we see in previous generations.
Can you explain a little bit more the difference between common law and precedent? Why do you differentiate them?
So classic common law is where you have actual, what you might call standards or rules of law that didn't come from any statute. So for example, there might be a rule in personal injury cases that says you can't win a lawsuit against a railroad unless you can prove that you looked both ways and were cautious enough before you tried to cross the railroad tracks. There might be no statute whatsoever that sets out that rule. That might be a judge at the state level who decided this is the best rule for a fair system of tort law. That's what we call personal injury law with respect to trains. But it didn't come from Congress. It didn't come from a state legislature. It simply came from that court coming up with what it thinks is the best rules. We've developed a lot of rules without the need for elected legislators. It's basically courts say we're the best equipped to figure out these rules of the road decision by decision. Those count as precedents as well. But at the federal level, most of the precedents are not so much about that. They're about statutory interpretation. And those are not so much common law because they're coming from statute, but they're still disputes. There are questions where does the statute mean A or B? And once you have a precedent saying it means A, that also is binding on future courts. The difference is the court isn't supposed to decide what the statute means based on what it thinks is the best policy. It's simply supposed to decide what does this statute mean based on the best interpretation of it, whether the judge agrees with that statute or not. So that somewhat distinguishes classic common law iterative process of creating good policy versus statutory interpretation, which is supposed to be purely legal questions divorced from the judge's own policy views.
At the moment of the founding of the United States, what do we know about what was intended to be the role of the Supreme Court? What does the Constitution say specifically that the Supreme Court should do? Because like everything in a Constitution, it was rather vague. And how has it progressed or the evolution of it over time?
Yeah, the Constitution gives by far the fewest words to the Supreme Court, to the judicial branch as a whole. It doesn't even set out any of the courts below the Supreme Court. It just says there shall be one Supreme Court and such inferior courts as Congress may establish. It says they'll decide cases or controversies, and that's about it. So a lot of what we've built up since then has been based on the understanding of what does it make sense for a judicial branch to do? What does it mean to decide cases or controversies? And probably the first biggest question was, is it appropriate for the judicial branch and the Supreme Court to exercise what's known as judicial review, which means reviewing is a statute or an action of the president consistent with the Constitution, and most dramatically and most importantly, potentially striking down or invalidating that statute if the court finds that it's not consistent with the Constitution. And that, of course, famously is what Chief Justice John Marshall wrote in Marbury versus Madison, a case from the early 1800s that established judicial review and that essentially made the Supreme Court put it on the path to being as powerful as it is today. It's a fascinating and wonky case in many ways. John Adams had lost an election to Thomas Jefferson. He appoints a bunch of people at the last few days of his administration, Federalists, allies to him, opponents of Jefferson. He sends out these letters that essentially say you have the power to, this is your letter showing that you have this office, show this to the appropriate people and you'll get to take office. One person, Marbury, doesn't get his in time, or there's dispute, and it's not accepted. And so he sues, and he sues straight up to the Supreme Court. Because a statute had been passed saying that for this type of dispute, you can go straight up to the Supreme Court. And cleverly, the Supreme Court, in this opinion by John Marshall, says that statute giving us more power is unconstitutional because the Constitution splits out what types of cases can go straight to the Supreme Court without going to any other lower courts first, and what types of cases need to go to a lower court first and can only be reviewed by the Supreme Court. So it's kind of a clever, brilliant move, because they gave themselves this tremendous power of judicial review, but they balanced it, or they seemed like they were being humble because the particular statute they struck down happened to be a statute giving the Supreme Court more power. So they were saying, no, we can't have this additional power of first review of this particular type of case. That the Constitution doesn't allow you to give this to us. But of course, that dispute, Marbury, that particular statute, that's not that important 200 years later. What's important is the fact that they established the principle of judicial review in the first place.
What was the controversy about that decision at a time? What was expected of the Supreme Court, and how did people react to?
Well, a lot of people thought it would be decided on much narrower grounds. So a lot of people thought they would simply resolve this dispute. Was he entitled to this appointment or not? Was it in time? So there was definitely controversy. Many people at the time thought, oh, he's aggrandizing too much power to the Supreme Court. But in the long view, my view is, if you don't have judicial review, then essentially every right you put in the Constitution is just a hope. It's not anything enforceable. The point of the Constitution is that someone has to invalidate things passed by majorities if these things we've agreed to in the Constitution are to actually have teeth.
Staying in that kind of last point that you made, what is the role of the Supreme Court in the checks and balances between the different branches of government?
The Supreme Court plays a crucial role in the checks and balances because often it's the very last decider in a dispute. It's important to stress it's not the only decider, but if you have a situation where Congress has passed a bill that might be unconstitutional, the president has signed it, the president is now attempting to enforce it, the last check, the last ability for this to get blocked is judicial review, is for individual litigants injured by that statute to bring a lawsuit and say, I think this is inconsistent with the Constitution, maybe it violates my free speech rights, my Second Amendment gun rights, whatever. You get into court and ultimately you get up to the Supreme Court. And sometimes these cases are about disputes between the other two branches. Most classically, if the president tries to exercise an authority that has not been granted by Congress, that is not based on any statute, but that the president claims is simply in his inherent authority. Justice Robert Jackson wrote a concurrence hugely influential, essentially saying that when the Congress has not granted, explicitly chosen not to grant the president powers, his powers are at their lowest ebb. It's most implausible that he has that power. Famously, the Federalist Papers described the judicial branch as the least dangerous branch. A lot of people think that ended up not being the best prediction. The framers thought that Congress would be the most powerful and most dangerous branch because it can write whatever statutes it wants. In the modern era, as we've seen more division in Congress and more difficulty in passing statutes, we've kind of ebbed away from that to more power in the executive branch and less power in Congress. We've also seen the Supreme Court push and pull in terms of how much it's willing to push back against the other branches. So in the early 20th century, the so-called progressive era, the Supreme Court was striking down a lot of new progressive economic regulations on the theory that they were violating private persons' rights to choose how they contract their employees, how they run their businesses, etc. We had the New Deal, Franklin Delano Roosevelt, a ton of new novel federal government programs. At first, the Supreme Court was skeptical, struck down a lot of them. Then eventually they kind of yielded to political reality, realized that maybe FDR was going to pack the court if they didn't start supporting him more often, and they pulled back in a really significant way, and I think an unfortunate way, and started upholding all of the novel new powers that FDR was claiming for the federal government and the executive branch specifically. Then we had the so-called Warren Court era, the 50s and 60s, where the court was protecting a lot of individual rights, social rights, desegregating schools, controversially the right to contraception and abortion, new criminal justice procedures. Then we had, again, a backlash to that. The 80s, you have a more conservative court. And up to today, we have an interesting mix where we have a court that I think is very strong and very willing to strike down things on some individual rights basis, especially free speech. It's a very pro-free speech court. It's very good, I think, at policing the separation of powers in some respects, things like striking down the Chevron doctrine, striking down some of the more, I think, absurd claims of executive power, again, when haven't actually been authorized by statutes. At the same time, we still don't have a court that's protecting economic liberty as strongly as I think it should. We still haven't gotten back to that early 20th century approach that I think was better, where the court was treating economic rights and personal rights at the same level.
A lot of news today are related to, for example, executive power on immigration and the Supreme Court. And you hear from one side that the president has the power to do something like that, like to decide who is an American citizen or not, for example. And then the executive power accuses the Supreme Court or lower courts of interfering with their power and kind of like a dictatorship of the judicial for trying to stop deportations, for example. Can you tell us what your analysis is of what is happening right now and the relationship between these two powers?
Yeah, a ton of issues all intertwined right now. So one of them you mentioned is birthright citizenship. The 14th Amendment, in the wake of the Civil War, they wanted to make sure that there was no dispute, no possible lack of clarity that the former slaves and now freed slaves in the South were U.S. citizens. So it said flat out, all persons born in the United States and subject to the jurisdiction thereof are U.S. citizens. So that's what's come to be known as birthright citizenship. And the interpretation since then, mostly I think affirmed by a Supreme Court decision in the early 20th century, was that even if you're in the country illegally and you give birth to a child on U.S. soil, that child is a U.S. citizen. President Trump is now disputing that interpretation. He says going forward, if you're not in the country legally, he doesn't want your child to be treated as a U.S. citizen. And that's going to go up to the U.S. Supreme Court. So you'll hear this in any instance, anytime courts strike down, exercise judicial review and strike down an action by the president, you'll hear it called judicial tyranny, anti-democratic. But ultimately, to me, the point is that if they're doing their jobs properly, they're vindicating a higher form of democracy, which is the Constitution that we all agreed to, and that is amended by supermajorities, essentially 3/4 of the states. Similarly, you mentioned immigration enforcement. Certainly, the executive branch has a lot of discretion in how it chooses to enforce the immigration law. We just don't have the resources to enforce all of it uniformly, and so every president makes choices about how much or how little are they going to enforce it. But again, they have to do that within the law, and the courts are fully in their right and justified to be reviewing these and striking them down if necessary.
I think it's very interesting that when I ask you these questions, you say, if he's right, if he's wrong, because there is no objective truth answer right now until you hear from the court. Like, would you say we can expect an answer, but in the end, there's not an answer until we hear back from them, listen to the reasoning, and we start developing rules that we don't have yet? Like, how does that work, that we don't have an answer?
It's a very philosophical question. Is there a right answer to legal questions? Do courts discover it or do they just make it? It's going back hundreds of years, we've had debates between so-called legal realists versus legal positivists. And those are kind of the two opposing ideas. Legal realists say, judges can do whatever they want. The law is just whatever judges say. Legal positivists say, no, there's a right or a wrong answer before they answer. Sometimes judges get it wrong, sometimes they get it right, but the important thing is just to help them get to the right answer. There's the law in the sense of what the Supreme Court has said, but then there's the law in terms of what's the right answer. And of course, in some famous cases, the Supreme Court has gotten it very wrong, such as when they upheld segregation in the 1800s.
You mentioned a bit ago how judges are not elected. Was it always like that? Has it always been balanced between two parties? What has kind of been the real world experience of having judges appointed by the executive?
Yes, the framers in the Constitution created this system of joint appointments. So the president nominates someone for the Supreme Court and for all federal courts, but they don't take office until the Senate gives their advice and consent. So you have a hearing, you don't have to, but in modern era, you have a hearing, you have a vote, and you need a majority vote by the Senate. And sometimes the Senate votes people down. In the early days of the country, the Supreme Court was not a very glamorous job. In fact, several people turned down the position or resigned it quickly for better jobs. They didn't have a lot of cases that they would hear because most law was at the state level at the time. And it was also a less glamorous job because they had to do something called riding circuit, which was that they would each go to different parts of the country, hear lower level courts, lower level decisions, sometimes trials, just to aid in the overall workload of the federal judiciary. So there wasn't at the beginning this notion that we would have two parties with very different judicial ideologies that sort of competed for majorities on the various courts. I'd say that started developing around the 20th century when you really had more polarization, more competing judicial philosophies between the two. But the key thing about the system, the key differentiator, not only are they appointed, but they have life tenure. They can't be removed. They serve, as the Constitution puts it, for during good behavior, which essentially means for life unless they commit a crime or something like that and are impeached. And what that means is that they have the freedom to go against even the president who appointed them. And the reason we have that protection is because legal decisions aren't supposed to be based on what the majority wants. So the president is thinking about popularity. Congress is thinking about popularity. They're supposed to be beholden to the people. The courts are not. A legal question is supposed to just have a right or a wrong answer. And even if only 10% are going to like the answer they give, if they think it's the right answer legally, they're supposed to make that decision.
Do you think there's some kind of value of having people that think differently on the Supreme Court? Otherwise, it would just be a reinforcement of the same idea again and again?
Yes, the Supreme Court does have a diversity of views. It's one of the bigger courts. It's 9 people. We have people going all the way back to appointed by the George H.W. Bush administration, Clarence Thomas, or as recently as the Biden administration, Ketanji Brown Jackson. And we have a mix of Republican and Democratic appointees, currently 6 appointed by Republicans and 3 appointed by Democrats. And they have often said that conflict of views, when they have tension, when you have a dissent, it sharpens the opinions on both sides, and it does prevent them from phoning it in. You also hear that in the oral arguments. Advocates have to be on their toes no matter what side they're on, because you know you're going to get tough questions from at least some of the justices.
I read an article in the Harvard Law Review that you shared trying to explain the remedies that a Supreme Court would have if you have an executive power that doesn't want to comply. And it made me think how fragile it was. It kind of hinges on this respect for the current system.
Another famous quote from the Federalist Papers: the judicial branch has neither force nor will, but merely judgment. So the framers knew that we essentially had to rely on the rule of law and our mutual consent to abide by judicial decisions. They don't have the army like the executive branch does. They don't have the police. We have the rule of law because even when the executive branch loses a case, it still abides by it. And ultimately that goes to the top, but it also goes to the bottom. Individual police officers, when they see an order, you need to release someone, they do it, they comply with it. It's drilled into everyone who works in the government system. A final judicial order is binding. You can't, even no matter how much you disagree with it, you have to comply with it. And that rule of law, that ethos, is hugely important. If you believe in judicial review, if you believe that the courts are necessary as a neutral arbiter, a tenure-protected arbiter of disputes about really contentious political questions as well as legal questions, then you have to have trust on that both sides are going to comply with it. In general, even in the toughest moments, the executive branch has complied with it. There are a few examples people will raise where it got pretty dicey. But again, we've never publicly had a president just say, I don't need to abide by it.
Going back to the Supreme Court itself and how they make their decisions, they don't necessarily have to be unanimous. So you have opinions, dissent opinions, you have the majority opinion, and sometimes even a dissent opinion might get more famous or more cited than the actual decision. Can you walk us through how usually they express the opinion of the court?
Absolutely. So this was another creation of John Marshall, the same one who wrote Marbury versus Madison. In the earliest days of the Supreme Court, they would simply say who won, and then every separate justice would write a little bit about what their thinking was, but no single justice was writing the opinion for the court, the official opinion that was their collective views of a majority. John Marshall said, no, this is too confusing, chaotic, people don't know what our singular reasoning was. I'm going to write a majority opinion for everyone who agrees with me when I'm in the majority, and you're all just going to sign on to it. You're not going to each write your own separate opinions. The current system is that you have the vote, you see who's in the majority. Whichever justice is the most senior in the majority will decide who has the responsibility to write that opinion. They even it up by workload so that each justice writes one majority opinion for each month that they sit. And then that justice by themselves with their law clerk will draft it over the course of roughly 1 to 2 months and then circulate it to the other justices in the majority. Then they circulate it to the justices on the other side who voted on the opposing side. And they similarly, the most senior justice in the dissenting side will assign a dissenting opinion, a primary dissenting opinion to someone else. Why do they take the trouble to write these concurrences or dissents, given that they're not the law. They're hoping to both explain themselves and they're hoping to influence the future. So one of the most famous bad decisions by the Supreme Court was Plessy versus Ferguson, which held that government-mandated segregation did not violate the Equal Protection Clause of the 14th Amendment. There is a famous dissent by John Harlan, who said, we have a colorblind constitution, separate but equal is not compatible with it. And indeed, that was such an influential dissent that it ended up being quoted quite often in Brown versus Board of Education in the 1950s, when the Supreme Court overruled Plessy versus Ferguson and said, no, separate but equal is not consistent with the Equal Protection Clause.
Obviously, not this system and not any system is perfect. But what, in your opinion, has made America work for such a pioneer in a system that wasn't tried and wasn't experimented with before it was implemented here?
Yeah, a combination of foresight and great design, and also some lucky breaks, I think. So the framers made a lot of good decisions in the Constitution, clearly laying out the separation of powers, not writing it too long. A lot of other national constitutions are much longer, much more specific, give less room for development or less room for that iterative process at the Supreme Court. They also, I think, made the right decision to put rights in the Bill of Rights, the First Amendment, which has been, I think, protects free speech better than any national constitution I'm aware of in the rest of the world. But we also needed a Supreme Court that was willing to enforce that. A lot of Justice Scalia famously said, the Soviet Union, it had a constitution that protected rights fantastically. It had a Bill of Rights that was even better than ours, but it was meaningless because it wasn't actually enforced by the courts. It was all a sham. That rule of law ethos in the country has been hugely important, and the only way you continue to have that is by people all agreeing to do it. They're less about making policy and more about just the guardrails that we have in place to make sure that policy is made through the best process.
How do you see the next years developing with the current administration and with the current makeup of the judges? What do you think we're going to see in the next few years?
The next few years are going to be fascinating, especially from a separation of powers perspective. We have so many areas where President Trump has claimed unilateral executive power or had implausible, in my view, interpretations of statutes, things like the tariff case, things like the birthright citizenship executive order, trying to shut down or move around government agencies. All of these are going to get up to the courts, and I think it's going to be a real test for the Supreme Court. A lot of the doctrines that they've developed over the last 4 years or so to strike down certain Biden-era policies, things like striking down the student loan forgiveness or the Clean Power Plan that would have shut down a lot of coal-burning plants. Those same approaches apply just as much, in my view, to what President Trump is doing here, an implausible reading of an old statute that was never intended to grant tariff-making power. So I think it's important for the rule of law that the Supreme Court, again, is consistent. It applies. It's not about policy. It's not about whether they agree with it. It's about down-the-line interpretation of what does the statute mean. So similarly, we may well see more conflicts between the President and Congress. Some of the foreign policy issues, things like the airstrikes in Venezuela, those could potentially get to the courts. Again, the president has a lot of discretion and power when it comes to war making and foreign policy, but it's not unlimited. Sometimes the courts will say, no, you need a declaration of war, or the law of war doesn't extend this far unless you comply with certain guardrails. So I think that's going to be the biggest issues are going to be President Trump claiming power for himself without congressional authorization.